All right, so this is the chapter three, end of chapter questions. In an insurance contract, the element that shows each party is giving something of value is called A, acceptance, B, consideration, C, offer, and D, purpose. So the correct answer is consideration. This is the element of an insurance contract that demonstrates each party is giving something of value. Here's why. Acceptance means the insurer agrees to the applicant's offer. Consideration is correct because it represents the exchange of value. The applicant provides the premium and truthful statements, while the insurer provides the promise to pay valid claims. Offer is just the proposal made by the applicant when they submit the application and premium. Legal purpose relates to whether the contract has lawful reasons, not exchange of value. So just remember consideration equals value exchanged. So legal purpose is a term used in contract law, meaning A, the contract must be a contract of adhesion. B, there must be an offer and acceptance. C, the contract must be aleatory. D, there must be legal reasons for entering into the contract. The correct answer is D, legal reasons for entering into the contract. Adhesion means the contract drafted by the insurer only. Offer and acceptance is a separate contract element. Aleatory means unequal value exchange. Legal purpose means the reason for the contract must be lawful and not against public policy. Insurance contracts always meet this test because their purpose is to provide legal financial protection. So the authority granted to a licensed producer is provided via the A, written contract, B, principal capacity, C, law of agency, or D, producer's apparent authority. The correct answer is C, law of agency. Um, this is because a licensed producer's authority comes from the legal concept known as the law of agency. This establishes the relationship between the insurer, the principal, and the producer, the agent. The producer is empowered to act on behalf of the insurer and the insurer is bound by producer's actions when they're within the scope of that authority. So the power given to an individual producer that is not specifically addressed in his or her contract is considered what type of authority? A, express, B, discrete, C, apparent, D, implied. The correct answer is D, implied. This is because express authority is written directly into the contract. Discrete authority doesn't exist in insurance law. Apparent authority is the authority that the public assumes based on company actions. Implied authority is unwritten but reasonably assumed as part of carrying out normal duties like hanging out brochures or business cards. So implied authority flows naturally from express authority. Blank is not an element of a valid contract. A, competent parties, B, countersignature, C, consideration, D, legal. So the correct answer is countersignature. Competent parties, legal purpose, offer and acceptance, and consideration, CLOC, are four required elements. A countersignature may appear on a policy but isn't required to make a contract valid. So remember, CLOC is all you need. Countersignature is not part of the legal essentials. So in an insurance contract, the insurer is the only party legally obligated to perform. Because of this, an insurance contract is considered A, conditional, B, unilateral, C, aleatory, D, voidable. So the correct answer is unilateral. So conditional means benefits are paid only if certain conditions are met. Unilateral is correct because only the insurer makes a binding promise to pay claims. Aleatory refers to unequal value exchange. Voidable means a contract may later be canceled by one party. Insurance contracts are unilateral because only the insurer is legally bound. So ambiguities in a insurance policy are always resolved in favor of the A, insured, B, producer, C, insurer, D, underwriter. So the correct answer is insured. This is because insurance contracts are the contracts of adhesion. They're drafted entirely by the insurer. If there's unclear or ambiguous wording, Courts will always rule in favor of the insured. Producer, insurer, and underwriter don't benefit here. The insured does. So when in doubt, ambiguities are resolved for the insured. So intentional withholding of material facts that would affect an insurance policy's validity is called A, misrepresentation, B, adhesion, C, concealment, D, estoppel. So the correct answer is concealment. Misrepresentation is a false statement. Adhesion refers to insurer drafted contracts. Concealment is a failure to disclose a material fact, whether intentional or not. Estoppel prevents an insurer from denying coverage because of its own actions. So concealment is the right answer, and if done intentionally, it can also amount to fraud. So what is implied authority defined as? A, authority given to act outside the agency agreement. B, the authority given in writing in the agency agreement. C, authority not specifically granted, but reasonably assumed to carry out duties. D, authority to handle claims and process payments. So the correct answer is authority not specifically granted, but reasonably assumed to carry out duties. So implied authority is the gray area of producer power. It's spelled out in the agency contract. That's express authority. And it's not just what the public thinks the producer can do. That's apparent authority. It's instead the authority that is reasonably necessary for the producer to perform their duties and meet client/insurer expectations. So which of the following is an example of the insured's consideration? A, insurer's promise to pay benefits. B, legal purpose. C, intent. Or D, a paid premium. So the correct answer is a paid premium. So the insured's consideration is premiums and truthful application statements. The insurer's consideration is a promise to pay benefits. A legal purpose is a separate event, and intent is not part of contract elements. So insured's consideration equals paid premium.